What if I told you the single most destructive decision an Indian founder can make is to win a lawsuit? It sounds absurd, but the top 0.1% of entrepreneurs understand a dangerous truth the rest don't. A victory in court is almost always a catastrophic business failure in disguise. You didn't pour your life into building a business just to watch your capital get incinerated by lawyers in a courtroom. Yet, when a conflict explodes, a key vendor defaults, a client refuses to pay a multi-lakh invoice, a co-founder dispute turns toxic, the default playbook is a reactive, costly march towards litigation. This is the playbook for the 99%, and it is a trap. We are conditioned to believe that when we are wronged, the court is where we go to be made right. For a founder, this belief is a lie. Litigation in India is not a strategic weapon. It's a symptom of a deep operational failure. It's a zero-sum game that guarantees 3 devastating losses, even when you win. First, capital burn. A dispute over a 20 lakh rupee contract can effortlessly consume 50 lakh rupees in legal fees, years of senior management time, and endless hidden costs. The math is simple. The win is a net loss from day one. Second, reputational hemorrhage. Every court filing is a public document. Your internal conflicts, your operational weaknesses, and your financial disputes become a public spectacle. This spooks investors, worries customers, and gives your partners pause. Your hard-won reputation bleeds out, one legal filing at a time. But the third loss is the most lethal. Momentum assassination. Your most precious, most finite resource is your focus. While you are trapped in depositions, reviewing legal drafts, and strategizing with lawyers, your competitors are shipping product. They're closing deals. They're capturing market share. The legal system doesn't care about your burn rate. It doesn't care about your product roadmap. It is a slow, grinding machine that hijacks your attention and assassinates your company's momentum. This is the reality of playing legal defense. You are letting an external process dictate the pace of your business. And in the startup world, the moment you stop moving forward, you're dead. But the top 0.1% of Indian founders, they operate on a different paradigm. They don't react to conflicts. They architect systems to contain them before they ever begin. They understand that the goal isn't to be proven right in court. The goal is to achieve the optimal business outcome with maximum speed and minimum cost. They don't hire lawyers to fight fires. They use legal strategy to build a fireproof empire. They use a system, a battle-tested operational protocol we call the 3D Conflict Containment Framework. This framework has 3 dimensions, each designed to protect your capital, your reputation, and your focus. Dimension 1, deflect. This is your foundation. You win future battles today by embedding conflict deflection mechanisms directly into your company's legal DNA. It starts with your contracts. Every single one, with co-founders, vendors, clients, employees, must contain a mandatory, multi-tiered dispute resolution clause. This isn't boilerplate, it is your fortress wall. It forces a sequence. First, a 15-day period of mandatory negotiation between senior management. No lawyers leading the charge, just business principles solving a business problem. If that fails, step 2, mandatory mediation. Both parties must sit with a neutral third-party mediator in a confidential session before any other action is possible. Only if mediation fails is the dispute escalated to step 3, private binding arbitration. The courthouse doors remain locked, and you add one more shield, a cost of conflict provision. It states that the losing party in an arbitration pays the full legal costs of the winner. This simple clause kills frivolous claims before they are even born. It forces everyone to weigh the economic reality of a fight. Dimension 2, de-escalate. When a conflict breaches your deflection shields, the immediate goal is not mobilization for war, it is surgical de-escalation. Before your lawyer drafts a single notice, you must run the 10 for 1 rupee analysis. For every 1 rupee you are fighting for, you must coldly calculate the total cost to recover it. Factor in legal fees, management time, distraction, and potential reputational damage. You will quickly find that pursuing a 10 lakh rupee claim could cost you 25 lakh rupees in real terms. This triage removes ego from the equation. Consider the SaaS unicorn that faced a multi-crore client threatening to sue over a delayed feature. The legal team's impulse was to fight. The founder intervened. Using their mandatory negotiation clause, they got on a call. They shifted the conversation from legal liability to business interests. They discovered the client's real fear was being deprioritized. The founder offered a service credit and a dedicated manager. Result? The lawsuit was averted and a 5 crore rupee contract was saved. That is a de-escalation win. Dimension 3, decide. When a dispute cannot be resolved, you still need a final decision, but you don't need a public court. This is the power of arbitration. Think of it as a private court system where you choose your judge, an expert in your industry, not a generalist. You set the timeline, months, not years, and you guarantee confidentiality. A booming D2C brand was nearly torn apart by a co-founder impasse. Their shareholder agreement, built on the DEFLECT principle, mandated binding arbitration. Instead of a public, value-destroying lawsuit, they confidentially presented their cases to a D2C industry expert. Within 90 days, a clean buyout mechanism was decided. The business never skipped a beat. Its brand value remained intact. The market never even knew there was a problem. Stop treating legal disputes like one-off emergencies. A reactive legal strategy is not an asset. It is a critical liability. The 3D Conflict Containment Framework is an operating system for legal resilience. It's a fundamental shift from playing legal defense to playing business offense. You deflect potential conflicts with ironclad contracts. You de-escalate active threats with ruthless financial analysis. And you decide intractable disputes with the speed and confidentiality of arbitration. This is the system that protects your capital, shields your reputation, and liberates your focus. While your competitors are stuck in the litigation trap, paying that hidden tax, you'll be building your empire. The question is not if you will face conflict. The question is whether you have the system in place to contain it. Knowing this framework is the first step. But knowledge without implementation is just theory. To truly install this operating system into your business, you need more than just the blueprint. You need the tools. That's why we've developed the 3D Conflict Containment Toolkit. It's an interactive assessment that analyzes your current contracts and business practices to reveal your hidden conflict risks. It then generates a personalized step-by-step action plan to help you build your fortress brick by brick. Don't wait for a crisis to expose your vulnerabilities. Take control now. Click the first link in the description below to get your toolkit and turn legal theory into your competitive advantage.